my client, who was operating her 18-wheeler, was outside of her 18-wheeler at a loading dock whenever defense was backing up and pinned her in between the two 18-wheelers. So Mr. Daniels and I have been working on this discovery, and we've conferred a number of times. We just have a few that we haven't been able to agree upon, and wanted to seek guidance from you.
Okay.
I provided a binder to the court on Friday just for ease. Did you happen to receive that, Judge?
I did not. I apologize. Which I do have the chart here. You have which ones do you still have issues with?
It is provided a letter with them too. So as it relates to Summit's production, it is 2, 6, 8, 9, 10, 13.
So let's do this. So 2 is the title of the vehicle. Is that right?
Correct. And Your Honor, as it for 2, 6, 8, 10, and 13, on those, all I ask is that defense supplement his response, because if you look at his response, it says defendant is unaware of any documents its understands are responsive. And that is throughout all 5 of those, 2, 6, 8, 10, and 13.
So 2 and 6, the objections are overruled. The defendant is ordered to produce any of those documents in their care, custody, and control. What was the next one?
Yes, Your Honor.
We already removed most of our objections, including for 2 and 6.
Okay.
So, and we responded that we're unaware after doing a diligent search of any documents in our possession, custody, or control. So I don't know what else to do for other than to say we don't have title for our truck or our trailer as well. If they were referring to our trailer, we don't have title of that anymore either.
Your Honor, he's not objecting to it. He states in his response, it understands are responsive. It looks as an attempt to hide behind the question being asked. I'm just asking him to remove.
He's ordered to produce any documents in his care, custody, or control responsive to the request within 2 weeks.
Yes, Your Honor.
Thank you, Your Honor. 2,
What's the next
6, and that was 8 as well, and 10 and 13.
8 is the same thing. Produce anything in your care, custody, control within the. Is there a claim that are there any witness statements that you're claiming work product privilege on?
No, Your Honor.
Okay. So anything in your care, custody, control within the next 2 weeks, objections overruled. You said 10 or 11?
10, Your Honor.
Again, Your Honor, with 8, we removed our objections. So
okay, anything involving, anything responsive in your care, custody, control within 2 weeks. What's the last one?
13.
Okay, what's your response to that one?
Your Honor, removed our objections, and we said that we don't have any tangible objects. So I don't, again, I don't know what she's looking for other than we removed our objections and said after searching we don't have anything.
You're ordered to produce anything in your care, custody, control within the next 2 weeks. So,
okay.
Anything else, Miss Hanning?
Yes, Your Honor. I'll skip to this one. Numbers 16 and 17.
Of this same request?
Yes, Your Honor.
Okay.
The onboard recording device. We have requested the logbooks and the entirety of the recording system. We've been provided with a couple of the things throughout the Omnitrax, but not the entirety of it. And that's what we're asking to be produced, is everything that the Omnitrax device, the report that it gives out, including the messaging system, the logbooks, everything that within the manual it states is within the Omnitrax, and we have not been provided all of that.
Okay, Your Honor, so this is 2 categories of documents that we have not removed our objections for, unlike the previous ones that you saw. In our supplemental responses, we didn't remove our objections because if you looked at the requests themselves, they go much broader than the Omnitrax device that Ms. Hanning's referring to. They're talking about any and all mechanical or electronic produced records on any kind of onboard recording device. So that would encompass, anything that's attached to the engine that does a download of the accident, anything that's on OmniTracks, anything that's on GPS, anything that's on cell phone, a different variety of devices, and each one of those devices puts out a large variety of different types of data. What we have produced so far and what we have told her in our supplemental responses is most importantly logs. We searched for them. Unfortunately, our client did not preserve them. She could do what she will with that information later on in the case. Those haven't been preserved. Those are the documents that contain the most wealth of information that plaintiff's attorneys typically like in these types of cases. We produced some other information that was preserved, and that's already in plaintiff's custody. The rest of it, I can't really remove by objections because those requests are not limited in any way, and they go too broad for me to feel comfortable saying I've given you everything when I don't know exactly what I'm looking for specifically. If they want to narrow it down, just say, hey, give me 30 days of logs. That's easy for me to respond to. I can say, hey, we've searched for them. We don't have them at this point. Same with GPS or same with, fuel tracking data. If she wants to get specific, I could give her a specific answer. When it's general like this, it's hard for me to answer them, Your Honor.
Your Honor,
Okay.
and I follow up on that. He has provided us with a off-route report that was provided through the OmniTracks. So it's just, it seems as if bits and pieces of the OmniTracks has been provided to us, but not the entirety of it. And it's not that the defendant was only working for the company for approximately 36 days before this accident occurred. So we're looking for which in the manual it states not being provided to us.
So like I said, Your Honor, we supplemented our responses specifically to say, after conducting a diligent search, defendant was unable to locate any logbooks for the driver involved in this incident. That's the end of the response to number 17. So I don't know what else.
They don't have any logbooks for this driver.
He was only employed for them, like Ms. Henning said, for less than 45 days. They didn't preserve the logbooks after the accident. This lawsuit wasn't filed till 2 years minus 6 days after the accident. So I didn't know if that had anything to do with them or their, reason for not preserving it. I don't know. That's for a later date. That's something that the plaintiffs can use.
I'm going to order these to be produced. I would caution your client that not having the logbooks is, you're facing a possible spoliation instruction and possible sanctions. I'm pretty surprised they don't have logbooks.
You're not the only one, Your Honor. The client was surprised and so was I. So.
All right. 16 and 17, the order to produce any documents in care custody control within the next 2 weeks.
Thank you, Your Honor.
Your Honor, 16 goes to the black box. It goes to any kind of electronic thing anywhere related to the cab of the truck. It goes a lot beyond logbooks.
And we're in agreement to it to be specifically as it relates to the OmniTracks information.
All right, that's ordered. So ordered. What else do you have?
36, Your Honor. And the same one is, yes, number 36, the drug and alcohol file. So throughout that, they provide the initial drug and alcohol test that he took on the date that he was applied for the job. And throughout their manual, again, it states that, a post-alcohol drug and alcohol test will be given post-accident. And Your Honor, their response just refers us to the drug and alcohol test provided or produced herein, which is only the initial one.
Again, Your Honor, we supplemented our response specifically to this question. We removed all the objections, and our response says, defendant responds as follows: see the drug and alcohol test produced herein. And that's the one test that my client has. They're not withholding anything. So again, I don't understand the follow-up.
Same thing. Any objections are overruled. Anything in the care custody control of the defendant needs to be produced in the next 2 weeks. Is there anything else?
Your Honor, 38 was driving logs as well, so that was covered.
Again, Your Honor, when I supplement and I remove my objections and I say this is exactly what I have, I don't understand the point for the motion to compel. And I appreciate your time in dealing with this. I know you just had a very long hearing, but it's when I've already conferred with my client, removed all objections, and then produced what I have, I don't know what else I could do.
You have anything else, Ms. Henning? I mean, if it's all the same issue, I'm going to rule the same way. And so,
Yes. I'm just flipping through real quick, Your Honor, making sure that there's nothing else.
okay.
The last one, I believe, Your Honor, is it is under Defendant Johnson's request for production,
Okay.
and that would be number 16.
Okay. What was the response?
Defense is, we have asked for the, as you see, the phone records for the day of the accident. They have offered to give us 30 minutes before and 30 minutes after. However, Your Honor, we still, we request the entire days of that. Just in the limited discovery we have received from them, we aren't able to tell the hours because there's no logbooks. The drug test, that's not provided in there, which is required post-accident.
I'm going to overrule the objection. All cell phone records for the day of the accident, especially since you don't have logbooks, are going to be ordered to be produced.
Your Honor, if I may, in lieu of producing the actual cell phone records, can we produce an authorization for them to obtain those cell phone records on the day of the accident?
I mean, can't your client just print them off?
I don't know if he can, Your Honor. That's the problem. Most of the time we provide an authorization and then we ask for a reciprocal one in return. So if they're asking for 24 hours, then we'd ask for the same 24 hours in return. And that's a dispute that plaintiff's counsel and I had back and forth and we're trying to hash out.
Your Honor, we offered 10 days of the cell phone records if he was willing to offer 10 days as well.
Your client needs to produce these. I understand if they don't have them, if they don't have access, but that's pretty unusual. Usually if they try, they can get them. So they're under their care custody control, especially if they still have that account. So that needs to be produced.
Your Honor, I believe that's it, Your Honor.
All right. Go ahead and get me an order on all of this, Ms. Hanning. Go ahead and email my court coordinator and as well as e-filing it. Make sure that on the order that you submit that it says on May 3rd, 2021 instead of on this day. And again, email my court coordinator and e-file it as well.
Yes,
Make
sir.
sure you share it with Mr. Daniels prior to sharing it with the court, just to make sure there's no differences of opinion on what the order should say.
Yes, Your Honor. Thank you for your time.
Okay.